three sponsored webinar IT Distinguished Lecture Series from 28th April to 3rd May 2020 by its distinguished speakers to engage, motivate, and mentor the students during lockdown period due to COVID-19 pandemic. It is my great pleasure to share details and introduce today's guest speaker to you, who is going to deliver the topic innovation and intellectual property rights. Intellectual property plays an important role in providing a competitive edge to organization. The assets of an organization, such as know-how, inventions, brands, designs, and other creative and innovative products of today are often more valuable than its physical assets. This presentation will cover the need to adopt innovative approach in the working and to protect quality inventions with intellectual property rights to get maximum benefit out of it. Brief profile of Dr. Shashi Rana, who is a speaker of this session, is Chief Consultant, Patent Minder and IP Associates and Intellectual Property Rights Enterprise, former Joint Director, Council of Science and Technology, Uttar Pradesh, Lucknow. She did her MSc in Chemistry from Lucknow University and PhD from Department of Microbiology, King George Medical University, Lucknow. Formerly, it was King George Medical College, affiliated to Lucknow University, Lucknow. She has 33 scientific publications, 10 international and 23 national to her credit, and one chapter related to scientific and allied work. She was awarded by Rashtra Manavadhikar Sanyukt Parishad UP in year 2008, having around 20 years experience of heading the Patent Information Center at CST UP. She worked to encourage and facilitate the society at large and scientists, researchers, especially for protection of their intellectual prowess. She was also nodal officer for IPFC MSMES sanctioned by Ministry of Micro, Small and Medium Enterprises, Government of India. She also headed Research and Development Division and Mapping of Science and Technology Needs of the State Program. Presently, she is engaged as a Chief Consultant in Patent Minder IP Associates. Dr. Shashi Rana, please.
Thank you, Dr. Tripathi. Good afternoon to all of you. First of all, I thanks to the organizers for giving me this opportunity to be present here. Presently, we are really going into a different and difficult time due to COVID-19. And I heartily hope that all of you, especially the students, are staying safe and healthy. I'll talk on innovation and intellectual property rights. And the subject, I will take this top lecture in dual language. I hope you will have no problem in it. So to start with, the creativity, invention, and innovation. These are the three basic things for the development, for the growth in this knowledge era. Creativity, this is very simple but great to mention, because sometimes there is a confusion between invention and innovations. Creativity is the ability to doing the things differently, beautifully, and for the first time. Creativity in some person is God-gifted, in some it is acquired for their passion, and in some for their profession. But the creativity leads to good innovation, good products, and good processes. Then invention can be defined as the creation of a product or introduction of a process for the first time. In reference to the intellectual property right, any invention is especially the technological innovation. Here, the things are done, it is a product or a process came out first time, and it should have an inventive step. It should have novelty, it should have inventive step, and then it is invention. Innovation, on the other hand, is if some value is added to the invention, it is the innovation. Innovation needs, for innovation, what is required is the dissatisfaction with the existing state of art. It is required, and inquisitiveness. Both these things are required for the innovation. Innovation caters the need of the society, need of the person. So 2 examples are there. The glue stick composition, we all know that it is the scientific invention, but to make it convert it into the glow stick, what many things are required. So first of all, engineering development, then entrepreneurial skill is required to develop such a devices, such a product, and then management and market assessment, what are the requirements of the society, and then most important thing is supportive environment. All these things in compound, this makes the commercially successful innovations. Like अगर कोई यूनिवर्सिटी एक नैनो मटेरियल डेवलप करती है, नैनो मटेरियल इज डेवलप्ड in the laboratory, but it cannot be go to the market directly unless these are tested for this. It's life, its toxicological studies, its field trials, and also government policy support. So all things, many things are required to get an invention, to convert an invention into the innovation. Then we all know that type of innovations are generally categorized into the 4 types, which are the sustaining, to get the things or the product sustained in the life, in the market. There is no big inventions like Lifebuoy or the Surf Excel. Similarly, incremental inventions, best example of incremental inventions are television or the iPhones or the Gillette razor. These are the which are as per the consumer's need. The purpose is to sustain the market, but to give a better product to the society, to the users, to the target group. And then disruptive innovation, disruptive technologies are very much in nowadays, because disruptive technologies, these are the technologies which disrupts the already existing things and come up with a new phase, with a new system. And these very good examples of this is the Saregama, the music system, which is marketed nowadays. And a part of this, Alibaba, Ola, Uber, these are all examples of disruptive technology. Then radical innovations are the breakthroughs. These are not done very quickly, but these innovations are the inventions like very good scientific inventions like the gene sequencing, robotics, blockchain technology, vaccine preparation. These are the inventions which are very breakthroughs. They caters the need of the local as well as the global nature. But innovation may be done in the product, in the process development, it may be in the service delivery, it may be the marketing process, it may be the external relation, or anything which is commercial, which needs profit, and then it can be innovated. But ultimate aim of the invention is to improve the quality of the product, because quality innovation is the new face of the quality nowadays, and enhancing productivity enhancement, a part of the reducing the cost of production as well as cost of the produce, both reducing the cost of the both, and then enhancing competitive position and stay healthy, stay well in the competition. We have a lot of challenges because with the globalization, lot of products are there. Life of the product is becoming shorter and shorter. There are high uncertainties there. More than 60% products flop in the market, and pressure to use the resources efficiently is always there. Whether it is the raw material, or it is energy, or it is electricity, or it is water, we have to use these resources very efficiently. Then what is the problem with us, that we don't use IP system judiciously presently. And then to manage both the quality and innovation is must for keeping it in the business, or in at any workplace we have to. Some examples are there that which don't have quality innovation, because some of you maybe remember that in 80s Kodak was a very good brand of the camera and photography. लेकिन कुछ ही दिनों के बाद with the emergence of digital photography, Kodak जो है वो बिल्कुल out of market हो गया. They have not incorporated digitalization in their photography, in their system, in their cameras. And then Nokia, up to 2005, Nokia was very good brand, but Here also when दूसरी मोबाइल कंपनीज ने जब अपने डाटा और सॉफ्टवेयर को इम्प्रूव करा, तब ये सिर्फ अपने साउंड और अपने साउंड के अलावा अपने मॉडल पे लेके स्टिक रहे. तो नोकिया इज नोकिया नाउअडेज. सिमिलरली जीरोक्स एंड याहू. जीरोक्स ये बहुत समय से पहले इनका पीसी मार्केट में आया था, लेकिन इन्होंने इनका भी बहुत दिनों तक सस्टेन नहीं कर सका, जस्ट ड्यू टू not involvement of innovation was not done and not accepted or incorporated in the system. Similarly, Yahoo was very good marketing platform till the 2005, lekin it was Google competed. Google Glass is there. Google Glass could not see market because of its high pricing and also due to some privacy concern. Similarly, MapQuest, we can see the examples of all these things. On the other hand, there are some small innovation which resulted in very good return. The Post-it, we all know it was the accidental innovations which were done by Dr. Spencer Silver, and it was an accidental innovation, but it worked very well. Similarly, Velcro, its trademark and patents both are existing, and this is very good example of small innovation. Then upside down bottle of this tomato hench, which was developed in 1995, and for its design patent, the designer, the inventor got $19 million for this design patent. Then we all know these crazy straws, hula hoops, and the smiley, Smiley was developed in 1963, and it is still marketing very well. Then coming on the intellectual property right, it is not a new concept. It is not a new area, novice area nowadays. Consciousness had increased, awareness has increased, but still there is lot of this among the segment which do not know what is to be patented and what is not, what is to be protected under what, and what is where to go. So although intellectual property right is not a new, because it existed since centuries in India. We all know the case of Eclavia, the fate of artisans who prepared that, who constructed the Taj Mahal, and the secrets of Vedya and Hakims, which is still there. Laws are there, laws were there, but the form of these laws are changed very much nowadays. So what is the intellectual property? Intellectual property rights can be defined in very simple words. This the intellectual property is the property emancipated out of the intellect. It should be novel. Novelty is the main criteria of the intellectual. Novelty or originality. It is the main criteria of intellectual property. And अगर इसको हम proper law के अंतर्गत protect करते हैं, then it becomes intellectual property right. It should have commercial value also. Intellectual property acquires various, this is a bundle of rights, and it gives the creator or the inventor the exclusive right over the use of his creation over a period of time, for the period of time. Think away from the form. Thinking differently and creating product of commercial value along with protection of intellectual property is the need of time. Intellectual property transforms innovation into the revenue creation or the commercial advantage. It goes if innovation is supplemented with protected with the intellectual property right, the creativity comes with the invention comes with the advantage. What is the significance of intellectual property right? Since intellectual property rights have their certain quality, they have the quality products, so they first of all they motivate creators, they encourage innovators, they avoid intellectual property, prevent duplication of work. They focus on commercially relevant product, because commercial utility and novelty and inventiveness is must for the patent. So the commercially relevant products come out. Exploitation of workers is prevented. Then revenue generation, they fetch good amount after IPR is protected. Then these are very good source of technical information. If any student want to do some work, want to start any startup, want to do any new, take up any new product, want to make product or the change processes, then he must have to go through technical information available freely in the patent databases, trademark databases, and design databases. For his use, this is beneficial. So it is a very large source of technical information. Further, it prevents infringement and help avoid litigations. It stimulates creativity, and there are career opportunities, not even only in business, but also academic world, also for the as a career opportunities in itself, because engineering student can become patent agent and go. It is a very good and very smoothly going career, and then they can go for patent agent also, and they can use it, do IPR for their own development, own product development, or enterprise development. There are different type of intellectual property rights in our system, in our India. In intellectual property right, you must be knowing that it is divided into, mainly it is divided into a copyright and also industrial property. Industrial property take up the products which are related to the industry, from patents to geographical indications, from industrial designs to copyright, from plant variety protection to trade secrets, and industrial design to layout design. All species, whatever is, can be, कोई भी व्यक्ति की जो creativity और innovativeness है, वो किसी भी field में हो, we have the laws, we have the acts for protection of the intellectual property in this life. Like these 8 species are there for the patent, technological innovations, science and technology related inventions falls under the Patent Act. Patent Act 1970, it is amended in 2005. We have come a long way. We have shifted from process to product patents, और इसमें जो है बहुत amendments हुए हैं, इस system को सेवी बनाया गया है, system को easy, simpler, user friendly बनाया गया है. So patents come under the Patent Act. Then Industrial Design Act 2000. Under this, only what is protected? Design or the creativity incorporated to make a product appealing, to make a product attractive. The industrial design is only for the outer appearance. No physical contrivance is included in this. Third, then trademark, we all know that it is the face of enterprises, and Trademark Act 1919 is there. Trademark in India, trademark around 4 lakh trademarks are filed in the trademark registry in India. Although industrial design is not much, because less than 25,000 designs are registered in India. इनमें से भी 63% जो है से केवल Indian designers के द्वारा की जाती है. Although the scope is much, but design registration is on the downside. Then इसमें से IC layout design of integrated circuit is a new act. कुछ स्पीशीज इसमें से, कुछ एक्ट एंड लॉज हमारे पास पहले से थे. इंडिया में 150 साल पुराना हमारा पेटेंट एक्ट है, जो कि अमेंडमेंट्स के साथ यूज किया जाता रहा है. बट आफ्टर जो 2005 या 1995, we had some new acts are created in geographical indication, layout design of IC circuits, and plant variety protection and farmers' right. These are the 3 newly designed acts which are very much useful for the society. And these are all these acts are TRIPS compliant. These are very robust and TRIPS compliant acts. And although India has no act about no specific law about the trade secret, these trade secrets are protected under the contractual law of India. Coming on patent is the most important and most difficult also. We can say it is difficult for the science and technological invention, because the subject matter, especially the subject matter, is important. What can be patented and what cannot be. But it is an exclusive right granted by the country to make to the inventor for and give him the right to make, use, manufacture, and market the invention, provided some certain conditions stipulated in that law are fulfilled. This patent protection is given to the inventor for in lieu of the disclosure of the information, full disclosure of the information. And such level of disclosure is there that the person skilled in that art can duplicate that work in his own laboratory. So, it can be given away like other properties. It can be given away, it can be inherited, sold, bought, and like any other property, it can be used. Although it can abandon also, though only 5% of 5 to 7% patents which are granted are utilized, are commercialized. This is the thing, but other are the of incremental level. Why patent? Patent is must for the academic person, for the career it is must, for the startups it is important as they अगर ये फ्री राइडिंग के लिए छोड़ देंगे उसको तो उनके कॉम्पिटिटर्स उनके बहुत ज्यादा बढ़ जाएंगे और वो उनका बेनिफिट नहीं ले पाएंगे, क्योंकि पर्पस ऑफ द ग्रांटिंग ऑफ द पेटेंट इज सबसे पहले उनका R&D में जो उनका एक्सपेंडिचर है उसको सपोर्ट करना, उनका जो इनकरेजमेंट है, जो इन्वेंटरशिप है उसको इनकरेज करना, और सोसाइटी के लिए मैक्सिमम अच्छे प्रोडक्ट्स को जो है वो अवेलेबल कराना, क्योंकि सब जितने भी इंटेलेक्चुअल प्रॉपर्टी राइट की स्पीशीज है, सभी स्पीशीज फॉर अ सर्टेन पीरियड ऑफ टाइम ये प्रोटेक्शन एंजॉय करती हैं और उसके बाद ये फ्री हो जाती हैं सब जनरल पब्लिक के लिए। बट ये जो जितने भी आईपी हैं वो एजुकेशन के लिए और फर्दर स्टडीज के लिए हमेशा फ्री है। दिस इज नॉट कॉल्ड इन्फ्रिंजमेंट, दीज आर ऑलवेज फ्री। सो द पेटेंट इज एसेंशियल because it gives them legal protection, it motivates for R&D, quality products are available, and it gives the financial benefit also. Risk of infringement are lessened, and then the strengthen or the positive image of the enterprises through the patent. Condition for patentability: patentable invention should have novelty. Novelty is, although the patents are territorial in nature, these are granted in the limitation of the country, but the novelty is examined worldwide, level of the world, and novelty is examined through the online databases or the commercial databases, free available databases, and also the non-patent database also. These are also useful in ascertaining the novelty. Then the second important thing is non-obviousness, inventiveness. Inventiveness is also very important criteria for grant of the patent, because the invention should not be obvious to a person skilled in the same art. Then utility, industrial use must be there. Apart of this, one more thing, in our patent act, there are various list of the subject matters which are patentable, which are not patentable as per our act. So after deciding that one has to go for the patent, one has to see the patentable and non-patentable subject matters. This is the patent grant procedure. In any system, application is filed after checking the novelty, inventiveness, and industrial utility. At the part of the inventor should also check it, and then they should file the application. After filing the application, the procedure start, and the procedure is same, that it is preliminary examination is there, and then proper examination is there. There are the examination. Patent examination always done after the inventor send a request for examination in a particular format, and then there are two times they are given the opportunity for opposition, pre-grant opposition and post-grant opposition, to give the public को मौका देने के लिए, क्योंकि अगर उसमें किसी तरह का कोई objection है तो वो raise कर सकते हैं. But in the patent grant procedure, the timelines are very important. If the timelines are sometime missed, then the product may be abandoned or it may be withdrawn. Then trademark is a valuable IP component for any business. It should be created, it should be protected, it should be utilized judiciously. These are the very valuable business assets. These are the identifiers. This indicates what the product is coming from, which manufacturer, where from it is coming. It has certain quality associated with it. Trademark helps in creating a strong image in the mind of the consumers. It may be anything, one or a combination of words, letters, numerals, drawings, symbols, three-dimensional images, or combination of colors. Some non-traditional trademarks are also there, and traditional trademarks are there. Then different type of trademarks, these are given here. But to frame a trademark, while creating a trademark, it should be in the mind that the trademark should be distinctive. It should not be descriptive. It should be distinctive. It should be easy to see, easy to read, easy to spell, easy to remember, and easy to recognize. It should be impactful. ट्रेडमार्क ऑल्सो जब हम ट्रेडमार्क डिसाइड करते हैं तो उसके लिए भी हमें ट्रेडमार्क सर्च जरूरी है कि ट्रेडमार्क हमें किस क्लास के लिए करना है. और अभी 2014 जुलाई से हम लोगों का ट्रेडमार्क में सिंगल एप्लीकेशंस में हम 80 कंट्रीज में, वी आर पार्ट ऑफ द मैड्रिड आपका पॉलिसी का, और इसमें हम 80 कंट्रीज में एक साथ जो है वो फाइल कर सकते हैं एक ट्रेडमार्क एप्लीकेशन। सो दिस इज, और इंडिया में ट्रेडमार्क लगभग, जैसे मैंने बताया, लगभग 4 लाख एप्लीकेशन जो है इसकी ट्रेडमार्क की जाती है, और इसको बहुत ज्यादा टाइम भी नहीं लगता है इसको फेल करने में। दिस इज a trademark registration procedure. Then coming on trade secrets. Trade secrets is the oldest practice form of the intellectual property right. In India, as I said, there is no separate law for trade secrets, but it is protected under the contractual law 1872. Then privacy law for unfair use, and then employment agreement are there, MOUs are done, non-disclosure agreement is there, security system. But finally, to protect the trade secret is ultimately responsibility of the owner of the system or the business or the institution or the enterprise. Anything may be the trade secret or the undisclosed information in the form of undisclosed information. It may be a formula, it may be a pattern, a compilation, program, list of the clients, technique, methods, production plan, any constitution, composition, product costing, anything may be the subject matter for the trade secrets. Most known trade secret is the Coca-Cola and KFC chicken and McDonald's special sauces. These are closely guarded trade secrets. Then coming on industrial design. Industrial design is, as I have given, it is given to the creators who creates something to make the product attractive or appealing, and these help in developing, sometimes this helps in developing the brand also. Design Act is 1911, which is amended in 2000, and design means only the features of shape, configuration, pattern, ornament or composition of lines or colors applied to any article, whether 2-dimensional or 3-dimensional, in both forms, by industrial process or the mechanical manual processes. But in the finished article, it should be solely judged by the eyes. There is no litmus test for checking the originality of the design which is to be registered. लेकिन इसमें डिजाइन रजिस्ट्रेशन के लिए बहुत इंपॉर्टेंट है, इसमें जो एप्लीकेशन होती है उसमें डिस्क्लेमर देना पड़ता है कि नोवेल्टी रिसाइड्स एट दिस प्लेस. वी हैव टू सबमिट द, ये भी ध्यान रखना होगा कि दिस इज द ओरिजिनल डिजाइन. जिस दिन तक रजिस्टर करी गई है उसके पहले ये डिजाइन कहीं भी यूज में नहीं आनी चाहिए. Further, it should not be against the morality. It should not, और किसी इंडस्ट्रियल प्रोडक्ट के ऊपर अप्लाई किया जाना जरूरी है. सो देयर आर सर्टेन क्लासेस कि किस तरह के प्रोडक्ट के ऊपर ये अप्लाई की जाएगी. इट इज वेरी सिंपल टू रजिस्टर डिजाइन. इट ओनली 1000 rupees is the form. It is the design application form, in which only technical thing is the class for which he has to see the database or go to the IP India .nic.in site of the patent office to check the class in which class, what is the class number, and then we have to put the different जो भी डिजाइन है उसके 4-5 photographs, different views, front view, rear view, lateral view, bottom view, इस तरह से उसमें डिजाइन्स के फॉर्म्स जो है वो अपना फोटोग्राफ्स लगाकर इसको सबमिट करते हैं एप्लीकेशन के साथ. दो power of attorney is not required, but it is not so difficult कि we require the attorney, so it can be done by the creator himself. This is the design registration procedure. You should go through it. Then layout design of integrated circuitry, which is also due to the obligations of TRIPS. India has to frame this act, and it provides protection for the semiconductor IC layout designs. Layout design includes layout design of transistors and other circuitry elements. But in spite of this, what is required, like other intellectual property right, the originality is required. It should not be disclosed or used before applying for the registration. It should be distinctive, and it should be capable. It's distinctive. It should be, and it should be distinguishable that from any other existing designs. But still, हमारा जो ये एक्ट है 2001 में आया था, बट पहला इंटीग्रेटेड सर्किट लेआउट डिजाइन जो है उसका 2014 में ग्रांट हुआ है, और केवल 2 आईसी सर्किट्स लेआउट डिजाइन जो है वो ग्रांट हुए हैं. एक RDSO का है और एक किसी दूसरी कंपनी का है 2014 और 2015 में. Next comes geographical indication. अभी तक जो हमने डिस्कस किए इंटेलेक्चुअल प्रॉपर्टी, they were single individual or the group of individual or an institution. But geographical indication, which is a very new act, not new act now because it was implemented in 2002. So, but geographical indication is a sign used on goods that have a special geographical origin, and उनकी जो property है, वो property are attributed to that particular geography. Such products are protected under the geographical indication, and this particular species of IPR is it gives societal right. It is no single person can apply for the geographical indication, and no single person can get benefit of this geographical indication. India is very rich in such products which have world famous products and which have the attribution to their geographical area. So such products, there are more than 3,000 products are there, and the registry of the geographical indication is in Chennai, and till now 362 products are registered, are granted registration under the geographical indication. इसमें से उत्तर प्रदेश के 26 products हैं जिनको की geographical indication के अंतर्गत protect किया. One thing more कि अगर हम IP के अंतर्गत protect करते हैं, तो this is not just for the sake of the protection. We have to get it commercialized. We have to take it in a way that we can get maximum benefit, and also the society can maximum benefit. So geographical indication का जो period है, it is given for the period of the 10 years initially, but and it can be renewed after 10 years for the indefinite period. Then protection of plant varieties and farmers' right act is there. This is very new right, because in developed countries, plant varieties protected under plant varieties protected under the it is protected under the Patent Act, but for us, this is a sui generis system developed by the in India, and it gives, apart from the researchers and breeders, it gives right to the farmers also. Here also, novelty, distinctiveness, uniformity, and stability. These are the criteria on the basis of which the plant variety protection is registered. Plant variety is registered, and here, this is registered for the test is for the 3 subsequent crops. Then copyright. We all know that copyrights are the very exclusive rights given to creators. This is a bundle of rights, and these copyrights are we all know about the copyright. It is automatic right. This is automatic. Once the person creates the work, it is got automatic copyright. Only ये C का वो उनको लिखना होगा. But in the case of legal, अगर कोई व्यक्ति उनको legally prove करना है, तो copyright registration recommend किया जाता है. There are various categories in which copyrighted work is there. Literary work in which the literary works like books, poem, articles, data, computer programs. This comes under the artistic work. आपका paintings, photographs, architectural designs, musical, आपका जो musical है ये आपका graphical notions, cinematographic film, sound recording, broadcasters' right and performers' rights. These are the different subject matter of the copyright, very wide subject matter. But in the copyright, quality is not important. Originality is important, and only expression is protected. No idea is protected, no subject is protected. Only expression of the idea is protected. But it gives the as it is the bundle of right, it gives right to the copyright owner for the reproduction, for the communication to the public, performing the work in public, translation or adaptation, all these bundle of rights. And further, the rights goes on with the person to whom the work is, who has translated, who has performed these rights, further goes to this. Apart from these rights, there are some moral rights also, that no one, the authors are gets the moral rights also. उनके जो कृति है उसको कोई mutilation ना करे, उनको distort ना करे, इस तरह के rights जो है moral rights में आते हैं, जो कि कभी हमेशा author के साथ में रहते हैं. very short term. It's copyright are granted in 9-10 months in registration period. और इसका जो period है वो बहुत लंबा है. Person अगर ये multiple authors हैं तो फिर last author की जब death होती है उसके बाद भी 60 years तक की जो copyrights हैं वो literary case में रहते हैं. हालांकि broadcasting rights 25 years के होते हैं और cinematographic rights जो है वो 25 years के होते हैं. Then what are the recent? We have come a long way. जैसा मैंने कहा पिछले 15-20 सालों में 1995 के बाद से IPR का awareness different stakeholders ने start किया था. But इसमें हमारा ecosystem बहुत अच्छा हुआ है. All universities, all institutions जो कि पहले जहाँ पर intellectual property rights नहीं थे, they are also very aware and very serious about protection of the intellectual property. And patents in India, you can see by this graph कि patents जो है वो इंडिया में इंक्रीज हो रहा है, इनका एग्जामिनेशन इंक्रीज हो रहा है, इनका ग्रांट इंक्रीज हो रहा है और इनका जो डिस्पोजल है वो बहुत ज्यादा पेस पे हो रहा है. इंटेलेक्चुअल प्रॉपर्टी राइट का इंफ्रास्ट्रक्चर अच्छा होने के कारण, हमारे सारे एक्ट्स अमेंड होने के कारण, सिस्टम्स को फ्री होने के कारण और सिंगल मतलब विंडोज बहुत फॉर्म्स पहले कितने सारे फॉर्म्स होते थे लेकिन उसको भी सिंप्लीफाइड प्रोसीजर किया, यूजर फ्रेंडली प्रोसीजर्स हो रखे. जो बेसिक ईज ऑफ डूइंग बिजनेस जो हमारे प्रधानमंत्री का कॉल है उसके साथ में जो पेटेंट ऑफिस में जो हमारे सिस्टम में चेंजेस हुए उनमें से कुछ को मैंने यहाँ पे ड्रॉप अप किया है. कॉम्प्रिहेंसिव ई फाइलिंग फैसिलिटी, पेटेंट एंड ट्रेडमार्क्स के लिए ई फाइलिंग फैसिलिटी है. ई फाइलिंग फैसिलिटी में आपका प्राइस 10% का डिडक्शन मिलता है और 24/7 बेसिस पे टाइम बेसिस पे किया जाता है. पेटेंट गेटवे क्रॉस किया है. पहले कुछ बैंक्स का था, बहुत लंबी लिस्ट ऑफ बैंक्स है, कहीं से भी आप पेमेंट कर सकते हैं. इलेक्ट्रॉनिक पेस में जो इसका पेमेंट सिस्टम है उसको बहुत ट्रांसपेरेंट और सिंपल बनाया गया है. इसका जो नेशनल फेज में सिर्फ एक फॉर्म को फिल करने के बाद आप उसको नेशनल फेज में आपको सिर्फ एक फॉर्म लास्ट पेज ऑफ स्पेसिफिकेशन सिर्फ आपको फेस करना है. फिर इसका जो स्मॉल एंटाइटीज, एक एंटाइटी भी बढ़ाई गई है इसमें. लाइक पहले तो इंडिविजुअल यूनिवर्सिटीज एंड इंडस्ट्रियल एंटरप्राइजेस थे और अभी जो है वो आपका स्मॉल एंटाइटीज में एमएसएमईज और स्टार्टअप्स भी जो है वो इसमें आए हैं. इनके लिए भी बहुत ज्यादा एक्सपीडाइटेड एग्जामिनेशन की फैसिलिटी की गई है. पेटेंट ग्रांट का टाइम जो पहले कहते थे 10-10, 12-12 सालों में होता है, उसको शॉर्टन करने के लिए बहुत ज्यादा प्रयास किए जा रहे हैं और ये पीरियड को कम से कम किया जाने की कोशिश की जा रही है. हर चीज ट्रांसपेरेंट है, हर स्टेटस आप चेक कर सकते हैं, ऑनलाइन जर्नल्स आप स्टडी कर सकते हैं. इवन जो स्टूडेंट्स जो पेटेंट फाइल करना चाहते हैं वो अगर स्टेटस जानना चाहते हैं, वो अगर किसी पर्टिकुलर टेक्नोलॉजी का या इन्वेंशन के सब्जेक्ट मैटर का स्टेटस जानना चाहते हैं तो इसके पेटेंट ऑफिस की वेबसाइट पे उपलब्ध डाटाबेसेस को यूज कर सकते हैं. जो कम्युनिकेशन है वो बहुत फास्ट हुआ है. ईमेल कम्युनिकेशन है, मोबाइल पे इंफॉर्मेशन आती है, आपके मेल पे इंफॉर्मेशन होती है, डिसमिनेशन बहुत अच्छा हो गया है. फर्स्ट एग्जामिनेशन रिपोर्ट जो है वो भी आपकी कैन बी सीन थ्रू. पहले इन्हीं को आने में इतना टाइम लगता था कि इनके टाइम जो है वो शॉर्ट होता था. फिर हियरिंग के लिए जाना नहीं पड़ेगा, वीडियो कॉन्फ्रेंसिंग की सुविधा हो गई है. QR कोडेड ऑफिस कम्युनिकेशन, आपको सर्टिफिकेट्स वगैरह आपको आपके ईमेल पर प्राप्त हो सकते हैं. Then expedited examination capacity is enhanced. So part of this आपकी नेशनल पॉलिसी रिलीज हुई है 2016 में जिसको कि जो कि जिसने कि हमारे IPR सिस्टम को बहुत बेटर, बहुत अच्छा और बहुत यूजफुल बना दिया है. So this was all about the intellectual property right I have to say to you. Thank you. Thank you.
आवाज आ रही है?
हाँ.
Thank you very much, Dr. Shashi, for such a nice presentation. We are grateful for the time and effort you took to share your knowledge and experience with us. I believe our faculty, students, research scholars can benefit immediately from the method you have suggested. Thank you again for your guidance, contribution, and participation in this webinar. And I thank our Vice Chancellor, Director for encouraging to prepare for webinar and invite distinguished speakers of their stream. Special thanks to Dr. Sita Lakshmi Madam, Coordinator Webinar, Professor O.P. Singh, Coordinator TechWeek 3, and a big thank you to Mr. Abhishek Nagar, System Manager, for his smooth functioning of this webinar. Without his support and efforts, we could not get connected through Zoom and YouTube channel. Thank you again and keep yourself safe and healthy. Thank you.
Ma'am, a small update. There are about 50 people were watching it over YouTube. Other than
Okay.
the participants over here, there were about 50. They were watching over YouTube.
Acha. Okay.
It was really
Question?
informative.
Questions?
If there are any question over chat box, then you can. Is there any questions from YouTube, Abhishek? Small update. There are about 50 people were watching it over YouTube. Other than the participants over here, there were about 50. They were watching over YouTube.
Acha.